Mr. Derek Wright.
All right.
Raise your right hand. You swear firm testimony you give me true, whole truth, nothing but the truth?
I do.
See, state the first and last name for the state, for the court, please.
Right. Derek, D-E-R-E-K, Wright, W-R-I-G-H-T.
Good afternoon, Mr. Wright.
Good afternoon.
Forgive me for putting you on this stand. This is not a place that I know you normally reside.
You chose to.
Sustained.
I'm going to take these away from you. Put these over here. Mr. Wright, I will not be getting into matters of privilege. I'll just ask you a few brief questions regarding your interaction with the state as it relates to the witness that just testified.
Okay.
First of all, would you please tell the jury how long you've been practicing law?
It's a year short of 30 years, so 29 years.
And how long have you known Mr. Antonio Sledge?
At least 15, probably longer, somewhere between 15 and 20 years.
And forgive me, but were you sworn in? You were sworn
Yes.
in? Okay. And did you meet him first in your capacity as an attorney representing him, or did you know his family before you began representing him?
In a legal capacity first.
Okay. Do you know how many instances where you've had to represent Mr. Sledge in Fulton County? Without saying a number, are you aware of how many instances?
If I thought about it, I probably would come up with an accurate number.
Is it, have you had at least 10 occasions to interact with him on not criminal matters, but just matters, legal matters?
When you say occasions, are you referring to cases or just interactions? I've not represented him on 10 cases. It's far less than that.
Okay. Over the last 15 years, are you comfortable telling the jury how many cases that you had an occasion to represent Mr. Sledge?
I would say, for sake of being accurate to this one and the one they've heard about from before, and I think a misdemeanor case. So other than that, I would be having to really dig deep, and I think that's probably it.
Did the misdemeanor case happen 15 years ago?
Probably more like 6 to 8 years ago, give or take.
So what was the first, when you say you've been his attorney for 15 years, what was the first instance? What year was the first instance?
Again, I can't tell you. I'm not being difficult. I just don't recall. I just know that I did come in contact with him as an attorney. And then with many of my clients, I developed a relationship. So he is someone that I've considered a friend, and I know him, some of his family, and therefore I've had an ongoing interaction with him, both professional and personal, for 15 plus years.
All right. Is it fair to say he's not the only person that you've represented in criminal matters?
Correct. I've represented many, many people over the years.
Have you had occasion to represent many, many people in Fulton County over the years?
Yes.
Have you had occasion where when you make an entry of appearance with respect to, say, for instance, a bond hearing, but have been required to stay on as a person's attorney?
Early on, when I first started, you had some of that because, one, often you might get onto a case and then get appointed where the county pays you to stay with the client.
Okay.
So early on, there was sort of an advantage to getting on early, and then you could stay on if the client either retained you privately or the county paid you. Later on, that changed, and more emphasis was put on public defender and contract attorneys and other stuff. So I would say in the last 10, 15 years, not so much.
So if you signed on to represent a person in the last 10 or 15 years for one thing and wanted to withdraw, the courts have allowed you generally to do that?
Generally, it depends where you are. If you're in Toombs County, Toombs County don't let you withdraw. Once your name hits the paper, you're the attorney regardless of whether you get paid or not. Okay. There's some other counties like that.
Okay.
Fulton is generally pretty liberal, where Fulton, if you and the client come to a disagreement or if money, Mr. Green doesn't show up, that also is a reason that you can sometimes get out of a case. So from that standpoint, Fulton is a little more understanding that sometimes the attorney and client have to go separate ways.
Without getting into the specifics of what you may have shared with your client, unless he waives it and you've been given permission to, and you'll have to tell me if that's the case.
Well, I'll tell you now, he has not waived attorney-client privilege.
That is fine.
So I am restrained by the laws
That's
of our
absolutely
state.
okay. Okay. So without getting into anything that is privileged information, would you tell the jury if information that is said between you and your client in the presence of others, such as Lieutenant Lancico, a lawyer from the state, whether that information is considered privilege?
It's a two-part answer.
Yes.
From an attorney-client privilege standpoint, that conversation may not be privileged because it's been said outside of me and the client, meaning there's more individuals hearing it.
Right.
From a plea negotiation, and whether plea negotiations are admissible in a court of law, that is beyond the attorney-client relationship, but an admissibility issue. And therefore, the question of this conversation isn't so much an attorney-client, but whether if it's a plea negotiation or it's the furtherance of one, is it admissible?
Okay. So have you been sitting in court during the entire time that Mr. Antonio Sledge has been on the stand?
Yes. Well, there may have been a
With the
one
exception of-
hour short period of time one morning where I had someone covering for me. But other than that, I've
Okay.
been here the entire time.
Were you present in court when he was asked by Mr. Steele about a June 2024 meeting in Fayette between Lieutenant Lancico, yourself, Mr. Sledge, and myself?
Yes.
All right. Do you recall that meeting in Fayette County?
Yes. It was the Starbucks in Fayetteville, my place.
And how would you characterize that? First of all, how long did that meeting last?
I would estimate maybe plus or minus 40 minutes.
Okay. And generally speaking, how would you characterize that meeting, the content, the purpose?
Often when you enter into an agreement with the state, you'll be asked to come in or meet with them to discuss questions they may want to ask, subjects they may want to cover. And basically, it's almost sort of like a prep session. And from the defense side, we're also trying to get an idea. What are you going to ask us? Where are you going with things? So it's sort of both sides feeling each other out. And that way, when we get to court, things can sort of go smoothly. And that was sort of what we anticipated. And that's generally what the meeting was. To be honest, we did not get into the details of testimony as much as I am generally accustomed to. Most of it was, Ms. Love, you getting to know my client and getting a feel for him, and vice versa. So honestly, a lot of the details weren't discussed. It was more of a feel each other out kind of meeting, in my opinion.
Okay.
Holding that rapport.
And do you recall me asking your client about any specific details of the case or the plea that he signed on December the 28th? There
There was discussion at that meeting about the plea that he had signed, a couple of videos, and again, I'm generalizing because I don't have an exact memory of everything. And again, because you didn't get into a lot of the details, like, to be sure, there was no script, there was no, here are the questions you're going to be asked. It was a very generalized kind of conversation. There was at one point, which y'all have talked about, a point where he started to share because he volunteered it.
When you say he volunteered it, what do you mean? Did I ask him something about it?
Mr. Sledge volunteered the subject of what Mr. Williams may have said to him.
Okay.
And to be clear, while it definitely wasn't what you were asking, it wasn't on the subject you wanted to cover.
You
Therefore,
say the subject I wanted to cover. Please explain what you mean.
you were asking, and I don't remember, to be honest, exactly what the question was, but it wasn't responsive to the question. That's why it stood out. And when you heard what he was saying about Mr. Williams, there was an immediate reaction where it was, that's not what I'm asking you,
Okay.
is what you said to him.
Uh-huh.
And he said, well, he went on, said what Mr. Williams told him.
And was that the part where he's saying he encouraged me to take?
Okay.
What part are you talking about?
This is what I've observed discussion in the courtroom about what he said about Mr. Williams telling him to take Woody to see the police.
Okay.
And the point was, as his attorney, as a defense attorney, I took it as that wasn't a subject you wanted to talk about and you weren't asking him about. But I can't say that I ever heard you say, don't tell the jury. It was nothing that definitive, but it was simply, that's not what I'm asking you. That's not what I've asked you to tell me. And ultimately, we sort of moved on from it, but it was just clear he very much wanted to say it, and that wasn't what you were looking for in terms of whatever the initial question was. So, but answering the issue at hand, I cannot say that you ever said, don't tell the jury.
And listening to the questions that I put upon your client during direct examination and redirect examination, where I've asked a question and his response has caused me to say, that's not what I'm asking.
Mm-hmm.
Would you characterize the interaction at that coffee shop as different than or similar to those type of interactions?
I would say, one, the overall interaction at the coffee shop was pleasant. No one was arguing, yelling, screaming, anything like that. It was very pleasant. You'd ask a question, he'd provide an answer. And then even when we got to that, it still wasn't combative. It was simply, that wasn't what I asked you, or what I'll ask you. It was, again, that just wasn't a subject you were going to be asking him about. So it sort of came and went.
And when you say that's not or wasn't a subject I was going to be asking him about, is it your testimony that my response had to do with the question? Your Honor, I'm not.
And honestly, he's a lawyer. He's going to be able to handle it. I'll give you a little leeway.
Thank you. When you tell the jury that I said, that's not what I'm asking you, was your understanding that that's not what I'm asking you related to the question that I had just asked that he seemed to have not been responding to?
It was to the question. That was not the subject matter or topic you were asking a question to. Again, I did not hear it. And again, maybe I'm biased because this is what I do, but I did not hear it as an instruction to say, don't you tell the jury this, or I want you to only tell them about that. It was, that's not what I'm asking you right now. I'm not going to ask you about that. As in, so I did hear that extra part, but again, it just reinforced the idea that you weren't instructing him to limit his testimony in any way. It was just clear that wasn't a subject you planned on going into.
Mm-hmm.
So as a defense attorney, of course, yeah, my bell rang and I said, that's a hot topic, but it wasn't any ethical issue because I didn't hear you in any way try to discourage him or instruct him not to convey that information if asked.
Okay. Now, were you present or were you asked by anyone else whether that was something that had been said?
Well, I wasn't asked, but I will say I am defense bar through and through for almost 30 years. Just as I, in this situation, sort of call balls and strikes. I'm not on one side or the other. And when one side has contact with me, I'll reach out and have contact with the other side to make sure both sides are getting information. Mm-hmm. And I did reach out and contact Mr. Steele, I believe, or it may have been Max, to say, hey, we did sit down, we had a meeting. Quite honestly, there's no big secrets or anything about the meeting, but I will say there was a situation where when one subject came up, it wasn't what she was asking about, but it resonated with me because knowing what the issues of this trial are, I knew my brethren in the defense bar would want to make sure they knew, Sledge knew, or was told by Mr. Williams to take Woody to the police. Now, I imagine they may already know it, but they may not have known that Sledge had that information. So just as the state was aware of it, I wanted to make sure the defense is aware of it. And I've also made him available so that if they wanted to question him, he could also be questioned by them. In other words, fair to both sides.
And were you present when Mr. Sledge was in communication via Zoom or some other way
Absolutely.
With Defendant Williams' attorney?
Correct. In fact, there's not been a single attorney that's contacted me, and it's only a handful of times, but they've always contacted me to talk to Sledge.
Okay.
Every attorney has shown perfect professionalism.
Love hates that
Were
answer.
you asked by any counsel for any defendant whether the state ever instructed Mr. Sledge to not tell the jury that defendant Williams encouraged him to go to the police?
Let me answer it in two parts. Yes, I have told them.
No, were you asked? That's the first question.
Oh, okay. Let me make sure I'm addressing the question because, you know, us lawyers, we like to talk.
So did Mr. Steele ask you if I told Mr. Sledge, don't tell the jury that defendant Williams encouraged you to go to the police? Did he ask you that question?
I don't recall him necessarily asking the question, but I told him my observation of that conversation. And Mr. Sledge told him his observation of that, really on the same Zoom meeting. So he actually, without having to ask it, received it from both me and Mr. Sledge. And even at that time, I said, I did not hear it that way, but if my client says he heard it that way, then he heard it that way. So it's quote unquote, two people hearing the same thing may take it a different way, especially one who is a defense attorney.
Did I inquire that of you after hearing that from Mr. Sledge? Did I ask you about that?
We have talked about it, yes.
And did you tell me that you told Mr. Steele? No, I didn't hear that.
Yeah. Well, I told Mr. Steele, I never heard you tell him, do not tell the jury. What I told you was that I've explained, I didn't hear her say that. I heard that she didn't seem to like that topic, but I can't say that I heard you instruct him. But my client insists that that's what he heard. So that's I know it's not a black and white answer, but that's the gray answer where my client has been very consistent saying, this is what he heard, but that's not what I heard. So I'm not gonna juice it up for the state or for the defense. I can only convey what I, in good faith, heard.
And is there anything in particular that you recognized or saw that made you think I did not like that topic?
Knowing the general idea of what the case is about, that ultimately the state's theory of the case that Mr. Williams.
Without getting into what you believe the state's theory of the case is, I'm asking you specifically what you observed that made you believe. And Your Honor, I'd ask.
That's not what she was asking, so no. Go ahead and ask your question.
Thank you.
I'm sorry, please go again.
I'm asking you what you observed me do or say facially, non-facially, verbally, non-verbally, that led you to believe in some way that I didn't like that topic.
The fact that
Is this about you?
you stopped him pretty abruptly, meaning as he was going into it, he sort of answered anyway. So it wasn't that you didn't yell, you didn't scream, you didn't do anything, but it was just, as attorneys, what we're really good at, I know we're gonna say talking, but listening and picking up. And when I saw that all of a sudden there was sort of a screeching stop point, that's when I realized, well, maybe, and again, not knowing the details of this case, maybe.
So is that where you drew your conclusion?
Let him finish his
Yeah,
answer.
maybe that topic, that point has some meaning and some significance. And that's where my thought was, okay, well, just as something may be significant about it in talking to the state, let me also make sure I've conveyed to the defense, hey, that might be some sort of topic. And again, I didn't know what he did or didn't do because my role sort of stopped pretty early in this. So again, my thought is if I'm neutral in calling balls and strikes, I want to make sure that they also are aware that may be a topic of interest. And but nothing about your body language or your mannerisms went to anything more than just, hey, maybe there's something there that someone needs to look into.
Did I tell him that's not what I asked in a way different than you've heard me say that when he's on the stand?
No.
Okay. And when I've said that's not what I've asked, when he's been on the stand, did you draw a conclusion that that was something I didn't want him to tell the jury?
I didn't draw the conclusion, but I did draw the topic was not the topic you wanted to talk about, which of course I said, why? But it wasn't, I didn't extrapolate from that, oh, you're trying to make sure he doesn't tell the jury.
Did you ever describe the meeting that we had as one where it was supposed to be kind of a get to know you kind of meeting.
Yeah, I mean, that's in truth, what it felt more like a, let's feel each other out, get to know each other.
And before your client offered up the information, Doug encouraged me to go tell the police or take Woody to the station.
Mhm.
Had I asked him any questions leading up to that?
That was towards the later part. You had already gone through some questions. I think we had asked about video. We had asked about the history of Cleveland Ave and the formation of certain gangs, notwithstanding YSL, but even before YSL.
Mhm.
So there had been plenty of conversation. And again, more of a get to know who Mr. Sledge is, where he's from, what part of the city, how he met folks, like how he met Mr. Williams and, those kind of things. So this particular part that we've been talking about, it wasn't the beginning, it wasn't the middle, it was probably more towards the end. And maybe 10 more minutes of meeting.
Had I asked him anything about Donovan Thomas's murder?
We clarified, as we did earlier, that one, he wasn't there, wasn't involved, and clarified he doesn't have specific information helpful to the state or to the defendants about the shooting of Mr. I'm blanking out that quick.
Mr.
Peanut,
Thomas?
yeah.
Okay.
I guess I know more so.
All right. Now, you mentioned videos. Were you present in court when I asked your client about the Lie to Your Mama video?
Yes.
All right. Do you recall in June of this year, while we were at that Starbucks, that is your spot, where I brought up the Lie to Your Mama video?
Yes.
Do you recall whether I simply went into, there's a video where someone talking about you lie to your mama?
I remember us talking about it generally because what was being discussed, not so much stated by him, but just discussed is, this is sort of a street topic. You might pick up on any street conversation where we're talking about, hey, you might lie to your mama, your daddy, your family, but when you're in court, you got to tell the truth. But
my question to you specifically is,
Weren't you finished? Mr.
yeah,
Wright?
that was it. That was it.
my question to you specifically is, do you recall me asking your client? I want to ask you about a video where they're saying you lie to your mama, you lie to your kids, and your client saying, that's not me. Do you recall that interaction specifically?
Partially. I remember the conversation and the topic. I don't remember his answer being no. I remember that conversation led to a conclusion that this is something that's just said in the street. And he didn't necessarily have a point of origin of it or this or that, but it was just something that's in the street. So that's why I can't give you an answer to both parts of your question.
Mr. Wright, do you recall me telling your client, so is the answer you don't recall him saying, that's not me?
Correct.
That's okay.
I remember it being played.
Like, you remember a video being played?
I want to say, I don't know if it was played or we heard the audio.
On what?
Well, that's what I'm trying to remember because we only had phones. We may have had a laptop. Again, and I could be incorrect. That's why the safe answer is I'm going to say no, because my recollection of that specific point is not, I don't know if we simply talked about a video or if one was.
I have a question. If she was asking, and this, you guys might not know this if you didn't watch around the time that Detective Gaither was on the stand, when Love spent hours and hours lying and arguing about this video, Keith Adams had to call her out, and Judge Glanville actually yelled at her. How was she asking witnesses about the voices in the video and who was who, just to go into court later and argue that there's only one voice in that video? How? How? Is it like the same thing as pretending not to know who Travis Scott is?
Shown.
Okay. Do you recall me telling your client, I have a video of him saying that?
You may have, yes.
Do you recall telling your client, act as if the state is God and they know everything? They already know the answers to the questions they're asking you. So don't try to be clever, just tell the truth.
It is customary when I.
No, wait, I don't mind the explanation. If I said it wrong, just say, no, you didn't say that.
I don't have a specific recollection of saying that, but it's customary for me to tell my clients, when you are in a cooperating posture, when they ask you questions, assume that they know the answer to the question they're asking you, that they're asking you not just to find out information, more often than not, they're testing you. They're trying to see, can they trust you or rely on your responses? Are you going to be truthful with them? So yes, it is likely I would have had that conversation. Would I have said God or some other analogy which made sense? Something. But it's more likely that I, at some point, made sure I said words to the effect of, when they ask you questions, assume they know the answer already. This is more of a testing, not a inquiry for information. So that's why I'm saying I may not have used those exact words, but I'm sure I probably did have that exchange in terms of the concept.
And when would you find it necessary to advise your clients in such a manner?
When they are in a cooperation agreement, and once we realize, they're putting us under subpoena, we actually have to testify. And then the posture sort of changed, that it's not just, hey, we're willing to testify. It's no, you're going to testify. And if you do, understand, you have to come in, you're going to have to tell the truth. And the state's going to question you and ask you some things. And when they do, that's when I would say, don't think you're going to outsmart them and you're smarter than everyone in the room. You need to almost assume they already know the answer to the question. And therefore, being truthful is always in your best interest. One, it's the right thing, but two, it's the smart thing.
Prior to that meeting, had you already been made aware that your client would be testifying?
Well, yes, the purpose of the meeting was, they are going to have us testify.
Right.
So we need to meet with them and see what questions they're going to ask. And like I said, just as y'all are feeling us out, we're feeling you out to get an idea. Okay, what things are they going to talk about? Are there any issues that are going to happen? And based on the plea and the fact that there was, we'll just say, some tussling or adjusting in terms of what the state was thinking of his factual proffers and what he was thinking, I figured this would also be a good time to start to iron some of those differences out and make sure that we're all on the same page as to what he can testify to and what he can't.
So you do not recall saying that in response to my telling him that we have a video of him saying they lie to your mama and you lie to your kids and get in the courtroom and tell the God's honest truth?
I may have said, wait. That's the video you're referring to. You're asking me, did I counsel him about assume the state knows?
In response to my saying to him, I have a video of you, not anybody else I'm talking about, but I have a video of you and him sitting back smiling. And then you saying that you have no memory of that.
I may have, only because listening to the dynamics of the situation, that would have been a time it would have triggered me to say to him, hey, this is, make sure you understand, you need to be straight with them. So I don't have a specific memory, but just knowing that I've been doing this a while,
Okay.
I'm sure I probably did.
Okay. Now, back in November of 2022, did the state seek, do you recall getting an email from me asking whether your client wishes to speak with the state about the case?
I believe November 17th.
Right.
I could be wrong, but I believe that was
All right.
when I received that email.
And you might have gotten one in November 17th. But did you also give one? I'm going to show you what I have marked and provided to counsel for the defense, but I'm willing to show again as State's Exhibit 450 Yankee, if anyone wants to see it. Sure.